or
Really?
consider.
That his wallet, ID, and all of his everything is still in his car. Or it does call the case, People versus Dylan Chapman.
Your Honor, Alexis Plumey, Assistant Public Defender, appearing with and on behalf of Mr. Chapman. Mr. Chapman, could you state your name for the record?
Dylan Chapman.
Thank you.
And Your Honor, today's the date text up for preliminary examination. I understand there is a bond violation. However, also at this time, people are unable to proceed as to counts 1, 2, 3, 4, and 5, and would ask for counts 6 and 7 to be remanded down to district court.
So you're unable to proceed on 1 through 5.
Correct.
Alright, pause right there. The prosecution just announced they can't proceed on counts 1 through 5. That's a massive development when 5 charges suddenly fall off the table. That usually signals weak evidence, missing witnesses, or a strategic reset. But don't get too comfortable. Counts 6 and 7 are still moving forward. This isn't a win. It's a narrowing of the battlefield, and sometimes that makes things even more focused and dangerous.
And would like 6 and 7 down. Got it.
Correct.
Counsel, you're moving to dismiss counts 1 through 5.
Yes, Your Honor.
Continue to defendant's not guilty plea as to counts 6 and 7. Set this matter for pretrial.
January 29th at 10:30 for Judge Brashour.
That date might change. There's an in custody thing. We'll see, but you got the 29th right now, correct?
Yeah.
Got it. What time? 9?
10:30.
10:30. Before Judge Freshour. As to the bond violation.
Yes, Your Honor, I have had an opportunity to discuss the violation with my client. He has provided me with an explanation that he feels comfortable with me sharing with the court. This was reported as a hit and run accident. Mr. Chapman states that the complainant in this case was using his car, which she had reached out to his mother and asked if she could borrow because hers was either broken or not able to drive in the snow. He states his mother gave her the keys to the car and allowed her to use it. And then Mr. Chapman states that at some point that night, his mother called him and let him know that the complainant had been involved in a hit and run accident with his car. He tells me that he did go to the scene of the accident to try to check on his vehicle, and that at that point, the complainant was not actually present. It's unclear to me in the report at what point in time the police.
Now we're getting into the heart of the bond violation. Notice how much uncertainty is in this explanation. Unclear in the report. Not sure when contact was made. In court, uncertainty is risky. Judges rely on clarity and logic. If the timeline feels foggy, that can work against the defendant. The key issue here isn't just the crash, it's whether he violated bond by being in contact with the complainant. That's the legal pressure point.
Police made contact with the complainant because it was a hit and run accident. I'm not sure if contact was made at the scene or later on, and there's not a whole lot of detail there. So Mr. Chapman is asking that the court consider keeping his personal recognizance bond in place, given that explanation, and potentially setting for a pretrial and bond violation combination in front of Judge Freshour, so that if there is more detail that needs to be provided, Judge Freshour could consider that.
Your Honor, at this point, I have concerns given the nature of that bond violation with his wallet, his other property being in the car. He's not there. I would have concerns about contact with the victim, being there with her, especially given the nature of the charges. So at this point, I would ask that he be remanded on the bond violation.
Your Honor, again, the only thing I will add is that Mr. Chapman explained to me that his wallet and other items were in the car when his mother provided the car to the complainant. So again, he's just asking that the court consider Yes, Your
That
Honor.
his wallet, ID, and all of his everything is still in his car.
Yes, Your Honor.
Clean sheet.
My understanding is that the car was supposed to be returned to his mother soon thereafter, and that Mr. Chapman said it was okay to leave his wallet in that case the complainant needed to use.
Okay, this is the detail that shifts the energy in the courtroom. He left his wallet, ID, and credit cards in the car intentionally from a legal standpoint that places his personal property directly at the scene. Judges look at common sense logic, and right now the question forming is, does this story realistically add up? Because when physical evidence like a wallet ties someone to a location, it raises serious credibility questions.
His debit or credit cards.
So how close was he when this vehicle crashed? Because they have him one driveway over.
Yes, so Your Honor, he states he did go to the scene of the accident after his mother told him that there was a hit and run crash to check on his vehicle. However, it's unclear to me in the report, and based on what Mr. Chapman is telling me, at that point in time, the accident had already happened and the complainant was no longer there, and he was just going to check on his car. So again, I'm not sure because it's unclear in the report.
How do I know the complainant's not there if she had the car? From this defendant?
So the complainant's not at the scene of the accident.
Yeah.
Right. We don't know. And I'm saying that it's unclear to me when contact was made with the complainant, at what point in time.
I hear you, but none of that makes any sense to me because it almost seems like he's with the complainant. The vehicle crashes, she leaves, and he's still there. That's why the only thing that makes sense as to why.
And there it is. The judge says the quiet part out loud. The court is essentially saying the simplest explanation is that he was in the vehicle. In legal reasoning, judges often rely on what's called reasonable inference. If the belongings are there and he's nearby and the complainant fled, the dots start connecting. This is the moment you can feel the judge leaning toward a violation, and once that lean starts, it's hard to reverse.
His wallet, ID, all of that stuff is still there because he was in that vehicle when it crashed.
And that is not the explanation that he is providing.
I get that.
Yeah.
But none of the other part makes sense. I'm not. Anything else?
No, Your Honor.
I think when I look at everything, that the defendant was having contact with the victim in violation of the bond conditions in this case, and based upon what was said, at this time, I will move his pretrial date up to January 15th, 2026. That's still at 10:30.
Yeah.
January 15th, 10:30. But at this time, the court's going to believe that there's enough evidence and to indicate that there's been a bond violation. I'm revoking the.
That's the hammer. Bond revoked, and legally this is significant. Revocation doesn't require proof beyond a reasonable doubt, just probable cause that a violation occurred. That lower standard makes it